welcome everybody. Good afternoon. Today we're going to discuss the Office of the Advocate for Business, my office. And first of all, it was created out of legislation so that business owners, particularly small business owners, would have one place to reach out to here at the Workers' Compensation Board for assistance. You know, simple as that. One place, one phone number, one email. And my office gets calls on a daily basis, and we assist individual businesses when they have easy questions and very difficult questions. Questions about coverage and compliance. I travel the state. Prior to COVID, I would go from Montauk to Buffalo and meet with business owners, government personnel, chambers of commerces, various associations, and basically do a workers' comp 101. You know, what is it, who needs it, how do you get it? And when I do that, now we do it obviously virtually, but many times I would hear things from business owners that would give us some pause to think about maybe what we're doing here at the board could be improved. And when that would occur, I report directly to the chair of the board, Clarissa Rodriguez, and I would report to her. And based on that reporting, perhaps systemic changes could be made. All right, so let's start off. What is workers' compensation insurance? Well, in New York State, it's a mandated insurance, and it covers on-the-job accidents, injuries, and illnesses. It provides medical treatment for those accidents, injuries, and illnesses, and a partial wage replacement. All right, it protects the employer as well as the employee because 99% of the time when an injured worker has a claim and the coverage is in place, the medical treatment and the wage replacement are there, and the employer does not need to hire an attorney because there's no lawsuit. The injured worker is being taken care of, both medically and from his wage replacement standpoint. That's workers' comp insurance. There's also New York State disability benefits insurance. That's also mandated, and that covers off-the-job accidents, injuries, and illnesses. However, with disability benefits insurance, there's only a limited wage replacement. There's no medical benefits, all right? If you use your disability insurance, you can receive a wage replacement of up to $170 a week. That's a maximum, $170 a week, and that's up to 26 weeks. That's disability insurance. Well then, who needs coverage? I'm a business owner. Who needs coverage and who doesn't need coverage? Businesses with employees need coverage. So who's an employee? Basically anybody providing any service to a for-profit business. They could be determined to be an employee of that business if a claim should arise, and any compensated individual providing services to a not-for-profit. They can also be determined to be an employee of that nonprofit with very, very limited exceptions, such as clergy or teachers that are working in an IRS-designated 501c3, okay? So if you're a church and you're paying the pastor, coverage is not required. If you're a church and you're paying someone to clean the church, coverage is required. All right. So let's say who's not required to carry workers' comp? A sole proprietor with no employees. It's me working for me and nobody else. You don't need it. Partners in the partnerships or members of an LLC, if they are the only compensated individuals, if there's nobody else, only partners or only members of the LLC, coverage is not required. Okay? A one or a two-person owned corporation, a mom and pop, they want to open a business. As long as each person owns one share of stock and they own all the shares between them, so it could be 50-50 or 99-1. If they own all the shares of the stock and they hold the offices of that corporation and there are no other employees, coverage is not required. Should they have a third shareholder, coverage is required. Should they pay somebody to answer the phone, coverage is required. Just the two of them, they own all the shares of stock between them, they hold the offices of the corporation, there's nobody else, coverage is not required. All right, so we know what it is, who needs it, so how do you get it, and how much does it cost? All right, Well, in order to get workers' compensation insurance, you need to go to a licensed insurance carrier here in New York that sells workers' comp insurance, all right? They're going to ask you questions because the premium, the cost, is an estimated premium. Unlike your car, where you know your car costs X amount of dollars and the insurance is going to cost you X amount of dollars for the year, here it's different. First of all, what is it you're doing? How hazardous is what you're doing? The more hazardous something is, obviously the more expensive it is. And then they take that amount, they apply it, it's a dollar amount. So for example, clerical work might be 30 cents, all right? They apply that then to each $100 of your payroll. So it's the size of the payroll, 30 cents now per each $100 of payroll, and then how safely you operate your business. The safer you operate your business, the lower the cost of your insurance. If you have many, many accidents, your insurance is going to go through the roof. At the end of 6 months or a year, you're going to get audited by your insurance carrier. Remember, I told it's estimated. They're going to want to look at they asked you questions when you started, how many employees you were going to have, what they were going to be doing. Now they want to see it, okay? They want to see if you use subcontractors. They want to see your books. You show them that, and they're going to get back to you, and they're going to tell you, you know what, you were right. We're right on the money. This is exactly the right amount of premium you paid. Or they're going to say, you underestimated, and we owe you money back. Or you overestimated, and you owe us money. So it's very important when you do your audit with your workers' comp insurance carrier that whoever performs that audit for your business is extremely knowledgeable about your business, can answer every question definitively so that you get a true audit, all right? And always make sure you show up for the audit. Never miss your audit. Some specific coverage issues we went over: the sole proprietors, independent contractors we'll get to in a moment, family members. Family members need coverage. You're going to hire someone that works for you, unless you set it up in a manner that we spoke about already, you need coverage. Domestic employees, you hire a nanny, you hire someone to come into your home. If they work less than 40 hours per week and do not live with you, coverage is not required. If they work more than 40 hours a week, workers' compensation insurance coverage is required. For disability benefits insurance, it's 20 hours a week. All right, if they work less than 20, you don't need it. More than 20, you need it. All right. When we talk about independent contractors, many calls come to my office because people aren't sure who's an independent contractor and who's an employee. We have a little quiz for you. Adam?
All right, thanks, Neil. You'll see on your screen here a scenario. I'm going to read off to you the notes here, and we want to get your opinion. So if you could just enter your answer, I should say, in the chat box. So we have Jen, and Jen would like to start her own SAT tutoring business. Jen will hire independent contractors for this tutoring business, and how it will work is the parents will contact Jen to match their child with a tutor. The parents will pay Jen, and Jen will then in turn pay the tutors for their services. So in this scenario, is Jen required to provide workers' compensation insurance for the tutors? Again, just write in the chat box if you want to answer yes or no. Neil and I will take a look and let's see what people are saying. We have, yes, she has employees, so she should have workers' comp insurance. We have a no here. So it seems to be a little pretty 50-50 split. Neil, what do we think?
Okay, the answer is unequivocally, it is yes. There's nothing independent about the relationship between Jen and her, quote, independent contractors. Why? Well, let's see. What business is Jen in? Jen's in the tutoring business. Who is she paying? She's paying tutors. Who's paying Jen? So the family's paying Jen to provide them with a tutor. Jen is paying the tutor to provide the parents with the service. There's nothing independent, all right? It reminds me of going way back. There was a restaurant in New York City. Every Wednesday night, they did lobster night. So the restaurant owner hired somebody to come in every Wednesday, considered him to be an independent contractor, paid him on a 1099, and he only used them one night a week. Unfortunately, there was an accident, and that cook had to go to the hospital. And the first thing they ask you when you're at the hospital is, did this happen at work? So the cook said yes, there was a workers' comp claim filed. And at the hearing, the judge said to the restaurant owner, why don't you think this person is your employee? Why do you consider him to be an independent contractor? And he said, because I only use him 1 day a week, and I paid him on a 1099. And the judge said, what kind of business are you in? And he says, well, Judge, I own this restaurant. And the judge says, well, you own a restaurant. He's a cook. What's independent here? All right, clue me in. Why do you think he's independent? And obviously, he was not. If somebody came into that restaurant to fix the air conditioning unit in the restaurant, that's an independent contractor, okay? So don't fool yourself. The moral of this story is don't fool yourself. Don't call something it isn't because you want it to fit what you want it to fit, all right? On the board's website, which is wcb.ny.gov, if you click on employer, you'll see the criteria that our judges will use, our administrative law judges will use when determining whether an individual is an independent contractor. The first thing is direction and control. Am I telling you what to do, when to do it, when to show up? Does the person have their own federal employer identification number? Are they truly a separate business? There are 12 criteria. You should look at them. After you look at them, if you still can't figure out if this person's an employee, should be an employee or an independent contractor, contact our office and we will give you our best advice in your particular situation. If you're in the construction industry, there's something called the Construction Industry Fair Play Act, which the Department of Labor oversees. And it's where workers are presumed to be an employee unless they can prove they have their own business, all right? If you're in the construction industry, go on labor.ny.gov, look up the Construction Industry Fair Play Act, and see that you're compliant. If you're a general contractor, under the law, you're liable for the workers' comp claim of any uninsured subcontractor, all right? So what you need to do, you need to, if you're using a subcontractor, you need to have them provide you with a certificate of workers' comp insurance that you can provide to your insurance carrier upon that audit. Because your insurance carrier, if they didn't have insurance, would be responsible to cover their claim should they get injured. What does that mean to you? It means that at audit, they're going to add more premium to you because they would have had to cover it. However, if the person you're using has insurance and you've given that proof of insurance to your carrier, they cannot charge you. We suggest that you have your sub add you as a certificate holder to their policy. It doesn't cost them anything. And why? Because if you had a bad player, all right, they can get workers' comp like auto insurance by putting a down payment and paying it monthly. So if you have a bad subcontractor, they can put a down payment, get coverage, give you a certificate of insurance. You give that to your carrier, and now you think you're good, but then that bad player doesn't make another payment, and the coverage lapses. So at the end of the year, you find out, oh my God, they didn't have the insurance. Well, if you were a certificate holder, you would be notified. And at that time, you could call that sub off the job until they got their insurance in place. If you were supposed to have workers' compensation insurance and you didn't, we will catch you. All right, we get notification related to payroll and other ways that show us who has coverage and who doesn't. All right, the penalty is up to $2,000 for every 10 days that you didn't have it, or $72,000 a year. There's also the situation where if you have up to 5 employees, it's a misdemeanor with an additional $5,000 penalty, and more than 5 employees is an actual Class E felony. And that's subject to a maximum additional $50,000 penalty and actual jail time. There's also something called misclassification. That's the same as being uninsured. We treat that the same. What is misclass? Well, you remember I told you how you got your insurance? You went to a carrier, they ask you some questions, and you tell them what you do, and they base their premium upon what you've told them. So if you're that same bad subcontractor, You know you got to get a certificate of insurance, so you got to get a policy. So you tell the carrier, everybody's doing clerical work, and you get a very inexpensive policy. But in fact, they're banging nails on a roof. That's misclassification. That's an egregious penalty, and it's something that is not thought of very well here, obviously. There's also something in New York called the debarment law. And what that means is that if you have any penalty with the Workers' Compensation Board whatsoever, you are barred from bidding on or being awarded any public works contract or subcontract with the state, municipal corporation, public body for a year, all right? If you have the felony conviction, it's 5 years. So you never want to lapse your insurance. You never want to have a penalty with us, even if it's a minor penalty. If you had a lapse for 11 days, all right? The penalty is the same as if you had a lapse for 4 years. You're barred from getting any contract. So make sure, you remember I told you about the audit period. Many times, my office gets calls from people who had a disagreement with their carrier when they were doing the audit. Or they missed their audit, all right? Sometimes they have a disagreement, they had an argument with the carrier, they don't pay the bill, there's a lapse. Or they miss the audit entirely, and there's something called an estimated audit that the carrier will do in lieu of having met with you. And when they do that, they generally increase the premium 3 to 4 times more than it was the year before. And so most business owners go through the roof, and they lapse their coverage again. They'll contact my office, we'll help them settle the problem, but now there's a lapse, and I can't help them off the debarment list. So make sure you show up for your audit, and if you're in a disagreement with your carrier, pay the bill. If you're right, you'll get your money back. If you're wrong, you should have paid it. But either way, you will not lapse. Should you get a penalty from the board, there is an appeal process. If you get a penalty, don't stick it in the sand. It's not going away, all right? But there is a way to appeal it. You send a letter to the board advising us that there was a problem, you had a lapse, you have the proper coverage. Attach the copy of your declaration page that shows us how much you're actually paying for your workers' comp insurance, and then we can reduce the penalty based on that. For example, let's say you hired a nanny and you didn't know you needed the coverage. She worked for you for a year, and it took us a year to find you. So you get a letter from us saying you owe us $72,000. Well, you send us the letter saying, geez, I didn't know I needed it. We got it now, and you send your premium page, and it shows the premium was $400 for the year. Your penalty would be the most, because it took us a year to get you, the longest amount of time, would be 4 times the cost of the premium for the year. So instead of a $72,000 penalty, you have a $1,600 penalty. That's the way we can reduce it. So if you know somebody that has a penalty, contact the board. The best way to control the cost of your premium is to make sure, A, you're in the right class code, and you can always check with your carrier if you think you're in the wrong one. If you still believe you're in the wrong code and your carrier doesn't give any credence to what you think, you can contact the New York Compensation Insurance Rating Board. They create the class codes. They can look at what you do, and they can instruct the carrier on which class code that you should be in. And most importantly, you should operate safely. Follow your claims. If somebody gets injured, work with your carrier. Get them back to work as quickly as you can. Maybe bring them back on light duty. The quicker you can get them out of that being out of work situation, the better it is for them and for you. And as I said before, operate safely. One of the things that you can do is create a labor management safety committee. You get equal members from labor and management. You make somebody the chair each month. You schedule regular meetings. And what you do is you meet and you walk the property, okay? Visit the workplace. Review the equipment, the sites, the procedures. Make sure the safe procedures are being taken. Most accidents occur when shortcuts are taken. And management has no clue about shortcuts Labor has the clue. They know what they do every day. So by working together, we can eliminate those shortcuts and make sure that those safe procedures are being taken. There's also something called a Workplace Safety Prevention Incentive Program, commonly called Code Rule 60. And that's when a business establishes a safety or a drug and alcohol prevention or return to work program. If they do that, they can save up to 10% of their annual premium the first year and 6% the additional second and third years. This is something that, again, the Department of Labor oversees. The website is there. You can visit it and see if it's something that you think your business could use. The Department of Labor will also come and do an on-site consultation program for you at no cost. They'll walk the property. They'll help mitigate safety risks. They're not going to be looking for violations. They're only there to help you mitigate your safety risks. If you're interested, the number for the Department of Labor is here. Next slide, please. All right, so your responsibilities as an employer are to purchase the insurance. You're going to get a poster from your carrier. Place it where your employees can see it so they know who their carrier is. If somebody should get injured, report that claim immediately. Section 120 of our law states that an employee cannot be discriminated against for filing a claim. You cannot take punitive action against somebody because they file a workers' compensation claim. If you have an employee that's out for a long period of time and you need to replace them, you can do that. We urge you to try not to do that. We urge you to bring them back on light duty, as I mentioned before. You can only terminate somebody for valid business reasons, misconduct, insubordination. You know what I'm saying, but if you do need to replace them because they're out on a claim, if you must, you can. And lastly, employees are eligible regardless of their citizenship or their immigration status. Which brings us to paid family leave. 2018, the governor signed a bill which gave New York State paid family leave, which provides job-protected, paid time off to either bond with a child, care for a sick family member, or assist a family member when they are being deployed overseas in the armed service. For bonding with a child, it provides time for both parents to bond with that child within the first 12 months of either birth, adoption, or foster care. For caring for a family member with a serious health condition, qualifying family members would include what you see here: a spouse, domestic partner, a child, stepchild, parent, parent-in-law, step-parent, grandparent, and grandchild. And effective January 1 of 23, siblings will now be included in eligible family members. Next slide. For caring for a family member with a serious health condition is defined as an illness, an injury, impairment, or physical or mental health condition requiring either inpatient care or a continuing treatment or supervision by a healthcare provider. COVID-19 diagnosis may be considered a serious health condition. When assisting a family member who's being deployed overseas in the military, they do it for short notice military deployment or military events or activities, the service member's rest and recuperation, maybe counseling, post-deployment activities, making financial or legal arrangements, and even child care arrangements for a military member's child. The coverage, virtually all private employers are required to provide paid family leave coverage. So as the employer, you have to purchase the insurance, all right? You get it from your carrier. It's part of your disability benefits package. You can deduct the cost of that insurance from the employee's paycheck. You can't do that with workers' comp insurance. You can do that for paid family leave. It is an employee-funded insurance. Employees pay the cost of the insurance. If you're a sole proprietor or self-employed individual, you can voluntarily opt in for this coverage within the first 26 weeks of starting your business with no waiting period, and then after 26 weeks, there is a 2-year waiting period. So time off and wage benefits. Eligible employees may take up to 12 weeks of paid family leave at 67% of their average weekly wage, which is capped at 67% of the New York average weekly wage. An employee's average weekly wage is based on their last 8 weeks of pay prior to taking paid family leave. And for 2022, the New York State average weekly wage was $1,594.97. Employees can take this paid time off all at once or intermittently, but it must always be in full-day increments. Who pays for the coverage? Well, I told you, it's fully paid for by employee payroll contributions unless the employer chooses to pay. The New York State Department of Financial Services, they set the employee contribution rate to match the cost of the insurance coverage. You can see the current cost information and a deduction calculator of how much to deduct from your employee's paycheck at paidfamilyleave.ny.gov/cost. Can an employee waive coverage? Well, an employee can only waive coverage if they regularly work 20 or more hours per week, but won't be in employment with that employer for 26 consecutive weeks, or they regularly work fewer than 20 hours a week and won't work 175 days in a 52-week period. Employers must provide a waiver form to all employees who qualify. And if you're an employee, you can get a template of the waiver form at paidfamilyleave.ny.gov. Employees who properly file a waiver will be ineligible for benefits and exempt from making contributions. Can a waiver be revoked? Well, if an employee's schedule changes such that they no longer qualify for that waiver, their waiver will automatically be revoked within 8 weeks of the schedule change. Employees will begin making paid family leave contributions along with any retroactive amounts due. So your responsibilities here are you need to obtain a paid family leave coverage, a policy, and pay that premium. And you do that with funds that you collect from the employee's payroll deductions. Provide information about paid family leave to your employees. Let them know what it's all about. And should an employee request paid family leave, you'll need to provide wage information to the carrier. Visit the employer section of paidfamilyleave.ny.gov for full details. COVID-19, unfortunately, is still with us. So if somebody works for you comes to you and tells you they tested positive for COVID-19 and they feel like they got it on the job, you need to contact your insurance carrier. They will file a claim with the board. It's not up to you to decide whether they got it on the job or not. There is COVID-19 quarantine leave. And what it does, it provides workers with job protection and financial compensation when they or their minor dependent child is subject to a mandatory or precautionary order of quarantine or isolation. Most employees will get financial compensation by using a combination of the benefits, which may include employer-provided paid sick leave, which depends on the size of the employer, paid family leave, and disability benefits. Your role in implementing the COVID-19 quarantine leave, whether you're self-insured or you're providing benefits through an insurance carrier, is largely the same as it has been for New York paid family leave overall. There are some new forms, COVID-19 quarantine leave forms, and they're available at paidfamilyleave.ny.gov/forms. Again, visit the paidfamilyleave.ny.gov/COVID-19 website for full details, which include guidance for employers. COVID-19 quarantine leave. For most employers with 10 or fewer employees and a business net income, annual income of less than $1 million, the employee can use a combination of paid family leave and disability benefits. After receiving their full paid family leave benefit up to $840.70 weekly, employees will receive disability benefits to match their full wages up to a maximum disability benefit of $2,043.92, for a grand total of $2,884.62 per week. And there is no waiting period for either benefit. Employees will have job protection for the duration of the quarantine. For most employees with 11 to 99 employees and smaller employees, 1 to 10 employees, with a business net annual income greater than $1 million, you're required to provide at least 5 days of COVID-19 paid sick leave. After that, employees can use a combination of paid family leave and disability benefits. After receiving their full paid family leave benefit, again, up to $840.70 weekly, employees will receive disability benefits to match their full wages up to a maximum weekly disability benefit of $2,043.92 for a grand total of $2,884.62 per week. And again, there's no waiting period for either benefit. Employees will have job protection for the duration of the quarantine. For most employers with 100 or more employees, as well as all public employers, you are required to provide at least 14 days of COVID-19 paid sick leave for a COVID-19 related quarantine, and that should cover the period of mandatory or precautionary order of quarantine or isolation. Employees, again, will have job protection for the duration of the quarantine. For more information on paid family leave, here's the helpline and the website. And here at the board, we're very happy. We have a brand new claim system that we've just released, and it's called Onboard. And basically, it's a real-time claim status for all of the players in the system. And what it means to you is it means your workers, should they get injured, are going to get faster, better treatment than ever before, and get them back to work, which is what you want them to be. If you want to follow us on social media, here's a way to do it. And this is my direct telephone, 518-486-3331. If you call this number, I'm going to answer, or one of my staff will answer. My direct email. Please reach out to us if you have any questions that you don't feel like discussing out in the public now. Just reach out to us, and we'll be there to help you. And now we'll take any questions.
Thank you, Neil. Yes, again, at this time, we'll take any questions you may have. Just please remember to enter them in the chat box. Keep your phone lines muted. I did see a question earlier about providing this slide deck. If you go to our YouTube page, I'll pull that link up right here, this youtube.com/New York State Workers' Compensation Board. You will find previous webinars on this topic that you can view at your leisurely pleasure. We'll also be editing this recording as well and uploading that within the next couple weeks, so be on the lookout for that. To be notified of when that recording is available, just sign up to receive workers' compensation updates. You can go to wcd.ny.gov/notify, and you can choose what you would like to receive updates on. I do want to also mention really quickly, Neil had mentioned paid family leave and COVID-19. We have a paid family leave webinar tomorrow at noon if you want to learn more information about that. Registration is not required for that, so just go to the paid family leave website, find the webinar section, and you can just hop on whenever, right before the webinar starts. And we will also be holding a webinar next Wednesday, which I believe is June 8th, regarding COVID-19 and workers' compensation and what you should know regarding what happens if one of your employees claims they got COVID-19 at work, and the process for filing a claim, and what you as an employer should know about that as well. So with that, we are going to start taking questions. There's going to be a brief period of silence as Neil and I review what's come in so far, and we will be back with you shortly. Thank you. All right, so our first question here, what if there is a third shareholder who's a silent partner? They receive no compensation benefits. Are you required to have workers' comp?
Yes. As I had said before, it only works with 2 shareholders. Any third shareholder, coverage is required.
All right, so I see a question here. If you're starting a new business, would you contact NYSIF for the insurance if it's just just the owner and one employee? Okay,
so NYSIF, New York State Insurance Fund, is an insurance carrier licensed to sell in New York State, as well as the private carriers that are out there. Any of these it would apply to. Yes, if you're starting a business, the key thing right here is you have an employee, all right? So you need coverage. If you want to be included in that coverage, you can do that as well, all right?
Can an employer receive email copies of all workers' compensation documents instead of physical mail?
At this point, we are still using regular mail.
Am I eligible to make a determination if an employee comes to me and tells me that they believe they caught COVID-19 on the job?
As I said to you earlier, no. Your job as the employer is to report it to your insurance carrier, who will report it to the board. It's not for you to make a determination.
All right, next question. Can an employer contact the insurance company to get updates on claims and how they're being handled?
Definitely, yes. As I mentioned earlier, you want to stay in contact with your carrier. You want to stay in touch with your claim. You want to stay in touch with your employee to make sure they're doing okay. And you want to stay in touch with the carrier to make sure that they're doing everything properly.
All right, next question. Do you have to have insurance in place prior to hiring an employee, or can you apply and have the employee start as soon as the application is in?
You should have your workers' compensation insurance in effect before any payroll is started.
That appears to be all the questions we have today, so thank you everyone for contributing and joining us. Thank you to Neil for another great presentation. I just want to let you know this webinar will continue to be offered in the coming months, so if you need a refresher at any point or if your colleagues couldn't join today, there will be other opportunities. You can find a list of webinar dates for this series and other webinars we have coming up at wcb.ny.gov/webinars. The next presentation for this will be July 6th. As I mentioned earlier, we do also offer a recorded version of this series on our website and on our YouTube page. So if you want to go to the website to view, you can just go to wcb.ny.gov and search for our Advocate for Business page. Again, you will get notifications on when the newest recorded version is available if you sign up for WCB notifications. Again, just go to our website. You can scroll to the bottom of the homepage and select Get WCB Notifications. We do also distribute information via social media, so please be sure to follow the Workers' Compensation Board on Facebook, Twitter, and Instagram as well to get updates there. Again, thank you all for joining us, and please continue to stay safe and enjoy the rest of your afternoon.